Just a moment.
Prakul sir, please start.
Yeah, I'm starting, ma'am. Just 1 second. Yeah. Good afternoon, everyone. Thank you, Anjali, ma'am, for the opportunity and also for the introduction. We'll quickly run to the topic, which is managing the business continuity during liquidation. So just as a quick uh, introduction in terms of the topic, so we are concerned with respect to a stage of this entire insolvency process wherein the corporate insolvency resolution, that is a CIRP, has failed. And we are still exploring to do something which we were doing under the CIRP, by which I mean we are looking at a going concern status. That's what the topic today is focused on. So just to reiterate the process, as we know in CIRP, the whole idea is to resolve the company as a going concern, and we target to reach out to the investors who will be willing to take over the company as a going concern during CIRP. Now, there might be several reasons why interest wouldn't have come for the purpose of acquiring the company during CIRP. It can be because of poor marketing, or maybe very shorter time for the investors to take a call to invest, or maybe at that particular point in time, the industry in which the CD is operating might not be um, favorable for any investors. So there can be umpteen number of reasons why corporate insolvency would have failed. I mean, resolution process would have failed. But there are, of course, examples under the code where a company has been brought into liquidation and subsequently it has been resolved as a going concern through a going concern sale. So predominantly, the very theory of liquidation comes from the fact that it is to liquidate the assets. So the very terminology liquidate has never envisaged a situation of going for a going concern concept at all. So the very idea of liquidation is to liquidate the assets, liquidate the business, and close the show and dissolve the company. That's always the case when it comes to liquidation. And the same you could find even under the Companies Act, the Traces of Companies Act also. The official liquidator was appointed to liquidate the company, thereby leading to a winding up and dissolution of the company. So this was always the process of liquidation across the globe, not just in the country in India. But as a deviation under the IBC, there has been, and honestly speaking, all these have evolved as a matter of case laws than as a matter of law. So initially, there was no provision for going as a going concern or as a compromise or arrangement. Subsequently, when the companies or the liquidators have tried to explore such options and they approach the NCLT and NCLAT, and or the until the Supreme Court stage, all the judicial forums have categorically stated that liquidating the company should be the last resort, because the very preamble of IBC talks about resolving the company. Now, so it was extended even to the liquidation process to say that, see, even in liquidation, if there is any possibility to revive this company as a whole and to continue the show, it is good for the economy. Say, therefore, it is not right for us to liquidate the assets when we know there is a possibility to revive the company as a whole. So that kind of comfort has come from the Supreme Court, from the NCLAT also on several occasions. In fact, there was no scope for a scheme of compromise or arrangement in liquidation at all. But again, as a matter of jurisprudence, this has evolved out of the rulings of the Honorable NCLAT in several orders, wherein they said that yes, definitely a scheme of compromise can still be explored during liquidation. And subsequent to such kind of a judicial activism, even the regulator has come forward with an amendment to the regulations to introduce an enabling provision which can empower the liquidator to propose for a scheme of compromise as and when there is such kind of a scheme of compromise or arrangement submitted to him by any of the party which is under consideration with the creditors, the members of the stakeholders consultation committee. So, though there are multiple procedures adopted in these kind of scenarios, the whole objective of this is that if at all there is an option to liquidate the entire assets of the company as a standalone basis, that should be the last option, is what this regulation talks about. So this regulation particularly comments that has to be, I mean, sorry, the entire liquidation regulations try to indicate that you should not try to go for an individual sale unless you are pretty sure that there is no other possibility of reviving this company. So that's where this evolution of continuity of business has come into picture. So I'll just share one interesting regulation under the CIR, under the liquidation process regulations on the screen. So this is under 32A, sale as a going concern. Under that, under sub-regulation 5. So the sub-regulation 5 has been introduced only in this year of February 2024. And it reads as follows. It says that where the liquidator is of the opinion that it is viable to run the CD as a going concern. So first and foremost, who should have this opinion that the CD can be run as a going concern? It is the liquidator. So as insolvency professionals, we should have an independent opinion on whether it is viable to run this CD as a going concern. So if I may give an example here, let's say if I have to run the company as a going concern, I'm incurring certain cost to run the show. However, the revenue I'm making out of it or the kind of benefit I'm getting out of it is overlapping, or rather is much better than what the cost I'm incurring, or is much better than the situation when I do not incur any cost in terms of running the show. And alternatively, let's say we are investing money by way of interim finance or whatever, or running the operations of the company through the working capital cycle, which we are trying to manage. And we realize at a later point in time that had we not run this company till this stage, so we would have actually incurred lesser cost because we're actually burning a lot of cost. There is no market to this product. And this is keeping on piling up a lot of unpaid liquidation costs during the process. So therefore, it is not a viable option. So when do we actually know whether to run the CD is a viable option or not will be a very interesting challenge when we read this regulation. But as you see this, I mean, the very intention of this regulation, as I understand this, is that right at the beginning of the liquidation process, one should know as a liquidator whether it is viable to run the company as a going concern or not. So I will stop there and again go back to explain one more idea of mine. I mean, one more theoretical concept here is that if at all, see, there is no possibility that right at the time of liquidation, you're thinking of running this company as a going concern. So which means there would have been a business continuity before the liquidation. So that therefore the decision is actually not whether or not to run. The decision is actually whether or not to continue this company as a going concern. Because till the CIRP process, if ideally this company would have been running as a going concern, that's where the liquidator will have a hope that, okay, I can continue to run this as a going concern. Right? So what is the meaning of running the CD as a going concern? See, under CIRP, there is always an assumption that every company has to be run as on a going concern basis. However, actual intention of a going concern is that there has to be running operations. There has to be a future of this particular business. That's what is ideally a going concern. So if you see that IBBI disclosures also, in CIRP 1 rather, they ask a question whether the company, the corporate data is a going concern, to which majority of us select no, considering that the company do not have any operations at all. But when an investor is interested in it, his interest or her interest will be to continue the operations, or rather invest more money and bring the company to operations and then take this forward. Probably that might be an interest of few of the investors. Similarly, when we come to but when it comes to liquidation, and particularly this sub-regulation 5, which is now mandatory with effect from February 2024. Now, as a liquidator, as insolvency professionals who are acting as liquidator for the particular assignments, we are responsible to opine whether it will be viable to run this company as a going concern or not. So here the words used are run the CD as a going concern. So this means, in my view, there would have been the CD in a position that it is being run as a going concern till now. Now, as a continuity, should it be viable for me to run the CD as a going concern? So that is the first question which the liquidator should form an opinion on. And based on the opinion, the liquidator should consult the consultation committee. The stakeholders consultation committee will give its advice. So the advice may be either to say that, okay, either in support of the opinion of the liquidator or maybe opposing the opinion of the liquidator. However, irrespective of it, as we all appreciate and we all are aware that the opinion of the stakeholders consultation committee will never bind the liquidator. The liquidator may still deviate from what is advised by the stakeholders consultation committee. However, he has to justify in writing as to why there was a deviation. Right. So basically, we have to consult the committee, and based on the advice from the committee, the liquidator shall run the affairs of the CD as a going concern to the extent possible. So the law is also pretty aware. I mean, the lawmakers are aware that, okay, it's not that it is very easy to do this or continue the show on a holistic approach. To the extent possible, they should try to run as a going concern in consultation with the committee. So just to give you some practical examples, like we would have seen a lot of sales as a going concern during liquidation. But in my practical experience and also based on the statistics, I don't think more than like probably 9 out of 10 companies, though they would have been sold as a going concern, might not have a running business as on the date it has been sold as a going concern. So majorly, the sale as a going concern has evolved as a concept wherein the entire CD has been sold. Again, which happens just like a resolution plan where the equity is transferred or maybe some other kind of a proposal. Second is where the business of the CD is sold as a going concern. So when it comes to the business, like if you take an example of a company undergoing liquidation, let's say it has three different business verticals. While two of the business verticals had totally lost its charm, there is one business which is still operating and we are making some money out of it. So the liquidator can definitely make a choice that, okay, I am going to run this business. While the other two, I'm going to initiate the auction and go for a sale of each of the assets of this respective businesses. This kind of a decision may also be possible for the liquidator to make, because there is definitely good amount of discretion and power on the liquidator considering the status and situation of the company. The practical scenario of the company has to be taken into consideration by the liquidator before any such decision is taken by them. Now, there are, I mean, when we consider that, okay, now for the sake of example, let us assume that there is one such company which has business being run by the liquidator. It's making certain revenue as well. Unfortunately, it ended up in liquidation, and the liquidator wants to continue the business. Now, what are certain hurdles which we identify, or which we can see in terms of such kind of a company? I'd like to take a minute to explain that. Now, when I mean that, what are the hurdles? There are certain legal aspects which we need to see, which will have a bearing on how we have to run the liquidation process and what level of assumptions we'll have to take legally or procedurally to see to it that we are able to continue the business as a going concern. Now, I'm reflecting on screen, section 33, subsection 7 of the code. Now, what does it say? It says that the order for liquidation shall be deemed to be a notice of discharge to the officers, employees, and workmen of the CD, right? So it is basically deemed notice of discharge to all the officers, employees, and workmen. However, except there's an exception provided in the same section, subsection 7, except when the business of the CD is continued during the liquidation process by the liquidator. So the very section 33 subsection 7 categorically indicates that, okay, the liquidator will still have a power to continue to run the business, in which case this order of liquidation cannot be deemed to be a notice of discharge. So anybody, any kind of aggrieved person, generally the erstwhile promoters or someone cannot go and claim that, no, all these employees are discharged from their responsibilities, etc. For the simple reason that this deeming provision only applies when the liquidator is not continuing the business during the process. So this is where I was implying, reading this subsection with this subregulation 5 of 31B, 32A. So what I conclude is that it's not more about running the CD as a going concern. It's more about continuing the business of the CD as a going concern. So ideally, there should have been a past in the CIRP that the company was run as a going concern. There are certain operations. So I feel it is ideal for the liquidator only in such scenarios to opine positively to mean that, okay, we can continue this as a going concern. Otherwise, to initiate the CD again or get the business back again during the liquidation process might not actually be a feasible idea, even to justify in terms of the opinion found by the liquidator, unless, of course, there are financiers, etc., who are willing to fund the respective business. So, 32A subregulation 5 of CA liquidation process regulations, read with section 33 subsection 7 of the IBC, provide clarity that liquidator has got a discretion to continue the business, right? So to run the CD as a going concern is what the regulations say. But as a section, it talks about continuing the business of the CD during the liquidation process. So that's when there is a leeway saying that, okay, there is no discharge of employees or officers or employees or workmen. The liquidator is free to continue the services even during the liquidation process. So that is with respect to the liquidation, the possibility of taking the company as a going concern during liquidation. Now, what is the business continuity we are talking about? See, in case of business continuity by liquidator, that the focus is not on making profits or making fortunes. The focus is more about handling or continuing the show till we hand it over to a successful buyer. So when we talk about continuity of business during liquidation, so the whole point is to ensure that the business is not, I mean, the very value of business is not diminishing. And how will it get diminished? The moment you stop the business, definitely there is an inherent diminution in the value of the business. So therefore, in order to protect that value of the business, the liquidator will take a call to continue to run the show, maybe at a lesser scale and at a very low volumes. But the whole idea is to continue to operate the CD so that the moment we go for marketing the asset, that would have a better marketability than over a company with shut operations but being contemplated to be sold as a going concern. Now, how in what way does this business continuity benefit the creditors? So the first and foremost aspect is that, firstly, it will definitely have a better recovery to the creditors, because generally any accruals made by the business during the process, the creditors will take complete distribution of that. So it's a usual case that whenever a company undergoing CIRP or liquidation process, it is able to make certain cash balances or has a certain credit balance in its bank accounts at the end of the period. It's always the case that the creditors will take will impose in the RFRP or be it in the liquidation also, stating that this amount has to belong rightfully to the creditors. So that is one thing which would help the creditors in terms of a better recovery than over a normal scenario. And nextly, the nature of assets is also extremely important when we talk about continuity of a business. So there may be certain assets which may actually become redundant if they are not put in use. And there may be even the value of the assets may deteriorate if the assets are actually not continuing to be used. So there are definitely such kind of equipments, etc., at the liquidator, I mean, at the corporators factories, which have a high bearing on the value realization at a later point in time. So therefore, I mean, for the liquidator and also for the SEC, it becomes utmost important for them to ensure that these assets are also protected. So there would be situations, I mean, at times protecting the asset as it is, in a sense that to ensure that the value of the asset is not deteriorated, it may be important for us to continue to run the company as a going concern so that the value of the asset remains intact and there will be a recovery. Otherwise, there might be a situation where the asset may not be in a position to be kept to use. So this is with respect to this. However, when we talk about this aspect of business continuity, the extremist benefit which we get is to better market for a sale as a going concern. So generally, when we go for a paper publication for sale as a going concern, usually we get replies from various investors showing interest. But the first question will be, is the company currently under going concern? So that would be the foremost important question for anybody who wants to bid for a company as a going concern. Now, see, let's try to go back and understand how the valuations are done. So we do it during liquidation valuation for each of the mode of asset. If at all you are appointing a new valuer. So assuming we are appointing a new valuer, set of valuers for the liquidation process. So there is a value assigned to each of the asset for the purpose of a sale of asset as on a standalone basis or as parcels or as a slump sale. So that for every mode of the sale, for every type of sale, we have a different kind of a methodology of valuation. So similarly, there are last two options of the sale of assets, which is sale of CD as a going concern and sale of business of this corporator as a going concern. There is an indication. So I'll just quickly show that part. So if we see here, we have like four of the options, which is standalone basis, slump sale, collectively, or in parcels. Now, in all these four situations, we have a different mode of getting this valued. In the other two, that is the sale of CD as a going concern and business of the CD as a going concern, this becomes utmost important because when the valuer is valuing these two, as per the international valuation standard, there is a presumption that the buyer is interested to buy this asset and the seller is interested to sell this asset as a going concern. So when we say as a going concern, we are talking kind of about the fair value, but which is undergoing a stressed sale. So the situation, the premise is that there is a stressed sale, but the assumption is that the company is having a business and the company is actually being sold as a going concern basis. So when we ascertain the value of this company as a going concern, we have an assumption that this company's business will be taken forward, that this company will be run as a going concern. However, when will this assumption be played in advantage of the company or the corporate data is when the corporate data is actually having a running business, right? So therefore, when we talk about running, when we talk about the aspect of continuing or running the business as a going concern, the whole idea is that it is to facilitate the sale of the CD as a going concern or the sale of the business of the CD as a going concern. Because when a business is actually operating, the recovery possibility will be higher. The amount of recovery will also certainly be higher. So that's the whole idea of this running the CD as a going concern. Why was it proposed and what would be the basic advantage of it? Now, if I talk about the responsibility of the liquidator or the role of the liquidator in this situation, first and foremost, it's important to acknowledge that whatever role we have as an RP or an IRP, similar role to manage the affairs of the CD will be there upon the liquidator as well. So as a liquidator, one cannot expect any dilution in the role or responsibility of the insolvency professional, irrespective of the position as an IRP, RP, or a liquidator when it comes to running the company as a going concern. Like, for example, let's take some couple of hypothetical cases to understand what level of role the liquidator has to play. Now, let's say, and I want to take it in the manufacturing sector so that the example, I mean, we can have more complexity to play with. Let's say the company is into steel manufacturing, it's undergoing liquidation now, but fortunately, there is certain business which the liquidator is running. Now, during this business and also during this process, we see that the directors have resigned. Now, it's a personal right of the director to resign, and therefore we cannot, as a matter of right, restrict the resignation of any person. So when the director has resigned and when as a liquidator, we are taking the show. So since it's a factory, in order for us to continue to have a factory license, there will be a demand from the respective department, the labor department, to ensure that there is, occupier. So the concept of occupier under the Factories Act is that occupier will be the single person responsible for the operation of the company and will also be responsible in case of any mishappening in the factory. So there are rulings, of course, in the IBC as well, stating that an RP can definitely be appointed as a occupier. So now in this case, by all means, because all the directors have resigned, the liquidator will by default become the occupier. Now, the moment you become the occupier, any kind of mishappening in the particular factory, it might be any accident causing threat in terms of injuries or having some issue in terms of the death of a particular labor. So all of this will come within the headache of the liquidator himself. So as a liquidator, they will by default become the occupier when there are no directors and there is no director designated as an occupier. So now, this way, the very responsibility of the liquidator is becoming multifold just by virtue of assuming the position as an occupier of this particular factory. So similarly, if the more complex the case is, the more businesses the company has, the more number of centers the company has, the more responsibility the liquidator will definitely have in terms of operating the company as a going concern. But ultimately, what the point I'm trying to make is the primary responsibility of running the company as the primary responsibility of running the corporator as a going concern will be with the uh, liquidator. So that's one point which I wanted to highlight. Next is with respect to compliance management. Just to give you an example, like recently we have been appointed in one of the liquidation matters to ensure that we are proposing to ensure that we are taking care of all the compliances of the respective of that particular company which is undergoing liquidation. So therefore, our primary role was to ensure that all the compliances, and it's a listed company. So there is a company undergoing liquidation, which is a listed company. And as a listed company, we were supposed to, I mean, for the listed company, we were supposed to undergo the compliance, take care of the compliances. Now, as we take care of the compliances, we understand that the NSC, I mean, it is listed only on NSC. There are several communications on the NSC for the compliances. Similarly, there are letters from the MCA questioning the liquidator as to why there were non-compliances in the past. So the idea is the moment we are continuing to run the company as a going concern, we cannot take any exemption with respect to compliances. All the liquidators are mandated to ensure that all the regulatory filings, compliances are taken place even during the liquidation if the business is run as a going concern. So the whole idea is that there would not, I mean, see, the moment we are running the business as a going concern, there may be certain relaxation in terms of the liquidation process, but the whole idea is not to give any kind of a special status for the same. So therefore, everything which is applicable on a company, if it is having a proper show business in its going concern, the same shall become applicable even the same shall become applicable even for the liquidator during liquidation process or for the corporator which is undergoing liquidation process. So compliance management will become one very important thing for the liquidator to sort, because the moment the liquidator doesn't sort this out, this will on the liquidator even for the negotiations in a private sale with for a sale as a going concern, or even for the public auction in when we are fixing the reserve price. These kind of an aspects that the more the if suppose the company has got a proper compliance, definitely the interest from the industry will be much better and higher. That is with respect to compliance management, which is again the responsibility of the liquidator. Next is with respect to managing the assets. See, when we talk about managing the assets, the most important aspect is that the liquidator will have the ideally, I mean, in any which ways, liquidator has the responsibility to maintain and take care of the assets or safeguard the assets. By continuing the business, it becomes much more easier, and also as a matter of process to monitor the entire assets of the company. The other important role of the liquidator is with respect to operational management. So the moment the liquidator forms an opinion that it is viable to continue or run the company as a going concern, the liquidator will also have to understand that the entire responsibility with respect to the operations shall essentially be the responsibility of the liquidator. Though the liquidator may the liquidator may definitely opt to continue certain employees who will run the show, but ultimate liability and responsibility will definitely be on the liquidator. Now, as regards the role of stakeholders consultation committee in when we are managing the CD as a going concern, It's important that this is one of the major challenges we may face as a liquidator when it comes to continuing the CD as a going concern. Now, the reason being that in CIRP, there are various provisions which stipulate what for what reasons we need to take a prior consent of the CD of the COC and all. However, in in a liquidation particularly, the liquidator will ideally become the boss. That is, the liquidator will have much better discretionary powers and also will have adjudicatory authority, like I mean to say, authority to adjudicate on certain things. So therefore, as a liquidator, during the CIRP, I mean, during this process of liquidation, so as a liquidator during this process of liquidation, one of the key aspects will be to manage the stakeholders consultation committee, because as required under regulation 32A subregulation 5, the liquidator shall has to consult with the stakeholders consultation committee before taking a decision, or maybe after forming the opinion, but before taking the final decision, the liquidator has to coordinate with the stakeholders consultation committee to decide whether to go for, I mean, to decide on continuing the CD as a going concern. So that in order for that to happen, it means that is one of the most important role of the SCC is to advise the liquidator on whether or not to take the company as a going concern first, whether or not to run the company as a going concern first. So that would be the definitely one of the major important roles of the SCC. And apart from the above, the SCC will also have the responsibility to ensure that the liquidator is timely providing the operational updates with the SCC, and based on that, they reassess the situation on whether or not to continue the CD as a going concern. So, see, as per the regulation, even though it states that you'll have to consult the SCC before, in order to ensure that the liquidator can run the CD as a going concern, so which is definitely appreciable. But at the same time, as a liquidator, the liquidator will definitely have the right to ensure that to ensure that at relevant point in time he may change his opinion as well, saying that okay, and now I don't think this turning the company as a going concern will be of any help, so therefore I am proposing that we not continue the business and let the new business be continued by the new management. That can be the scenario in when it comes to talking about the role of the SCC. Now, next and foremost is another interesting aspect with respect to role of directors and employees in liquidation. Now, when we talk about role of directors and employees in liquidation, as I was informing you prior, pursuant to that particular section of the code, that's section 21. So, what effectually, sorry, pursuant to section 33 of the code, essentially what will happen is the moment a company is ordered to be liquidated, the entire set of employees will be deemed to have vacated their offices. I mean, in the sense, the workmen and employees will be deemed to have not, will be deemed to have been discharged from their services. So it's like a statutory notice. So now, when that kind of a thing happens, it will be very difficult for the liquidator to gain the trust, and also to see to it that um, it will be difficult for the liquidator to see to it that this entire employees are acting in tandem or acting at the instructions of the liquidator. So that's why generally in liquidation, when we read it with section 33 subsection 7, if the liquidator is of the opinion to continue the CD as a going concern, then this provision of deemed discharge of the employees will not be applicable on the liquidator, or will not be applicable at all during the liquidation process. But secondly, when it comes to the role of directors and employees, it is extremely important, particularly in a case where we are exploring the possibility of sale as a going concern, and we are running the company as a going concern. It will be but at most important for the liquidator to ensure, it will be important for the liquidator to ensure that the employees that he is not losing on any further employees, maybe preferably the past employees of the company. And if at all, and that's one. And the second is that there has to be, I mean, the employee activism is something which is extremely important for us to run the CD as a going concern, and where possible, the operational expenses, including salaries to be payable to the employees and other expenses with respect to running the CD as a going concern, shall be strategically implemented by way of a budget and comparison of the same with the actuals, and to present, obviously, to present the same to the SCC on a regular basis. So this is with respect to role of the directors and employees in employment, sorry, in liquidation. And as we see, there is a dire need for understanding that sale as a going concern would mean that, I mean, the sale of CD as a going concern would mean that the business of the CD will continue, but it's just the game, so it's just the uh, uh, thing that, yeah. So, I mean, it's just a case that the business of the CD will continue as a going concern, while the entire CD per se will be sold as a going concern. So how does it operate? So we'll try to understand these two, the difference between these two modes of sale. One is sale as a going concern, sale of the CD, entire CD as a going concern, versus sale of the business of the CD as a going concern. So these are the two aspects, that is 32E and 32F. Is something which we will try to first understand, so that this will give way for us to realize the role of the liquidator in such a scenario. See, first and foremost, CD as a going concern. So there are options obviously on both of these aspects, either to go for a CD as a going concern or business of the CD as a going concern. But when they opt for business, I mean the entire CD corporate debtor as a going concern, there are multiple views there. So ideally, first they, I mean, if at all the intention was to keep derailing the process, then they would definitely, it would definitely be evident that, okay, they wanted to derail the entire process. So therefore, this entire CD is put for a going concern sale, even though there are various assets which have not made it to the to that respective advertisement. So when we talk about CD as a going concern, the entire corporate debtor, so it would include all the assets, because all the liabilities will be dealt with in accordance with Section 53. So all the assets with of the corporate debtor will be deemed to have been sold as a going concern. And with respect to the equity, any I mean, when it comes to equity in a situation of CD as a going concern, if at all the recovery is higher in accordance with Section 53, whatever is apportioned to the equity shareholder will follow on to the respective equity shareholder. So ultimately, when we talk about CD as a going concern, it has similar traces of how we will deal with the resolution plan, except for the condition that, the process which is identified for the purpose of selling the CD as a going concern is completely codified. So let's see Regulation 32A, which talks about sale as a going concern. So when we are, I mean, the very purpose of we understanding these regulations is to have a better idea as to how this business continuity is being ensured during the liquidation process. So when we talk about sale of the CD as a going concern, it says, I mean, sale as a going concern, it again says there can be I mean, see, this recommendation would have come even from directly from the COC level as well, right? So if the recommendation is coming from the COC level, then, you know, uh, if the recommendation comes from a COC level, it will become much more easier, and the RP will also have a responsibility to sell the entire CD as a going concern, instead of going by each of the asset being sold on a standalone or on a parcel basis. Next, the subregulation 2. This is of extreme importance, wherein it says that the group of assets and liabilities of the CD as identified by the COC shall be grouped. So basically, it says that the COC shall group these assets. Like, what are the assets, what are the liabilities for which we are doing this kind of a sale. So that's another important aspect. And if at all they fail to accept, obviously this is there. Yeah. Now, this is again extremely important. It says the liquidator may self-assess the assets of the CD under subclause C of 32 exclusively only at the subclause C, sorry, exclusively only at the first auction. So the wordings exclusively only at the first auction are the most important wordings to understand in this case. Now, what is meant by exclusively only at the first auction is that, so if at all you want to sell the assets under clause E of 32, so clause E of 32 is CD as a going concern. So suppose we don't want to club it with any other sale and we don't want to give any other option for the sale for the sale under regulation 32. In such a situation, we can propose for the entire, we can propose for only one sale, which will be the exclusive sale for under regulation 32E, without mentioning any other sub-regulations of regulation 32. Now, what does this essentially achieve? This essentially achieves the situation wherein there is no confusion amongst the bidders as to what they are bidding for. So the bidders are extremely clear that they are bidding for a particular value and they are bidding for a particular aspect, which is sale of the entire CD as a going concern. So, and also for the purposes of marketing, it is much more importance that when we are doing this sale as a going concern, the first auction should try to do an exclusive sale of the CD as a going concern instead of going for a standalone sale of or grouping of the assets. So that is with respect to regulation 32. And then with respect to sale of the business of the CD as a going concern. So now when we talk about business, we're only talking about probably one vertical of the company. So when we talk about one vertical of the company, it is extremely important for us to understand that a business per se will also have an inherent value with goodwill, and also maybe if it has customers, etc. So that will add a huge value addition to what is being transferred. So this liquidator as a strategy may even opt for this only for the sale of the business as a going concern by identifying what are all the assets which belong to the business. Right. So now what is essentially happening here is why should there be a reason for differentiating? So the reasons for differentiating the sale as a going concern versus sale of CD as a going concern can be can be multifold. So when we talk about sale of CD and sale of business, so when we say sale of business, so we can do a number of permutations, combinations to understand what all examples might fit in that. Like for example, let's say a company has multiple business operations, but only few of the businesses are operating. So there we can decide to either sell the entire CD as a whole, which will also have a couple of units which have absolutely no operation and the machinery is redundant and is of no use to you. Or you may also have a situation where you are taking the entire business. Only the respective businesses which are making money as being sold as a going concern, so that you can market the asset better and you can also ask for a better price to the respective asset which is being sold. So depending on the situation, you will have to assess as a liquidator whether sale of the CD as a going concern will be better, or sale of the business of the corporate debtor as a going concern. So this is something which, as a liquidator, the liquidator should take a call, and also of course take the advice from the stakeholders consultation committee. So this is with respect to this is with respect to this sale of the CD as a going concern vis-a-vis sale of business of the CD as a going concern. I hope the concepts are clear till now. So if there is any questions till what we have covered, feel free to ask. Otherwise, we can continue. Okay. So we don't have any questions as such from anybody in the group. I'm just checking the chat also. Fine. Okay. So we can continue. Now, Once now, when we move forward to understanding as to why this concept of say it's the continuing the business during the liquidation has been brought forward. So the very concept of continuing the business during the liquidation has been brought forward with a ideology with two intentions. One of the intentions is that the value will be preserved when the business is being continued, which is an obvious answer, I would say. But the other intention again is from a more of a social point of view, which is to ensure that the employment loss is also being curtailed. See, when we do not take care of this aspect, tomorrow even the businesses, if suppose a new business wants to come, finding employees who are working there or maybe similar skill set of employees will become a huge task. And also, of course, it's a direct indication of unemployment the moment we opt for liquidation on any other scale, whenever, particularly for a running entity. So therefore, even ensuring the employment and preserving the jobs, or I mean, reducing the job loss is also one of the major indications or targets for including this continuity, business continuity during liquidation. Now, but beyond all this, I wanted to for a moment focus on what level of challenges we face. So what level of challenges the liquidator faces when it comes to um, managing the business continuity. So this is something which we have to analyze as a liquidator to understand what level of challenges we may face when it comes to managing the CD as a going concern. Now, first and foremost situation will be to maintain and uh, to have a proper cash flow for the project. Now, as we all are aware, we all are, majority of us at least are not typical businessmen who might also, I mean, majority of us may not even understand certain financial acumen, or may not have certain financial acumen, or may not understand the business the way the guys who run the business understand. So, but beyond all that, of course, one major challenge will be is to understanding the business, which is always there, which we may substitute by appointing a kind of a consultant who can help us in that respect to business. But apart from that, maintaining the cash flow will be again a huge challenge. So, because the reason is there will be definitely liquidity constraints, because like for example, when I was working, uh, whenever I was working at ENY, I realized that yeah, when I was working at ENY, I realized that there was one company where we were operating the company as a going concern. But though it was not in liquidation, but I don't think the principle changes. Ultimately, the principle remains the same. So when we were doing it, when we were talking to the operational creditors, that is the suppliers, because they were supplying us a raw material, but they were expecting the payments to happen at the most. Majority of them are expecting the payments to happen prior. So there was no credit period offered to us because of the past experience of delays in terms of clearing the dues. Or even when we spoke to them to say that boss, see, the interim finance is guaranteed. I mean, whatever you do is coming under CIRP cost, and you will have a complete assurance of the recovery. There has been absolutely ruthless approach, considering that, see, even though they know definitely they are going to get back all this money, but they're unsure at what point in time. So playing by that, they were always like, okay, we'll give you a zero credit period. Either you take it or leave it. So that is a very huge challenge. So I would say working capital will become a huge challenge. Managing this kind of a cash flow will become a huge challenge for the companies undergoing this kind of liquidation process, because there will definitely be liquidity crunch for us. And even at the level of the customer or from the supplier end, there will be huge pressure considering our liquidity in terms of me paying the loans or whatever at the earliest. So that is one major challenge which we'll have to see. And yeah, and then with respect to second is with respect to employee retention. So the moment the company is in CIRP itself, always the moment we see the CRP itself, there's always a chance that employees usually tend to discontinue their services. So the moment employees are tending to discontinue their services, it will be highly difficult for us to convince them, because as RPs or liquidators, we will not be in a position to offer them increments or give them some kind of ESOPs, etc. So it's not a typical business situation for us to convince the employee to stay with us. So employee retention will become a huge challenge for us. When we are looking at continuing the company as a going concern. At the same time, for those employees whom we have retained, the maintaining the morale of the employees will become a huge challenge there. Because the moment we have retained them, obviously because of the less staff and rationalized work, we tend to use their man hours more and more than when they are generally, when there are more number of employees in the team. So basically, we'll get more work done using less resources, thereby firstly exhausting the employees, and secondly their morale in terms of continuing to work with the organization will also go for a toss, because see, nobody will be interested to associate themselves with a company which is undergoing stress or undergoing liquidation. So I mean, when I say nobody, I mean majority. So therefore that will again become a huge challenge for the liquidator to tackle, particularly when there are certain key employees who tend to do such kind of a situation. I mean, like when there are key employees who will have such kind of a concern to continue with us. So because if we don't have such key employees, it will be extremely difficult for us to continue the show. So therefore, as liquidator, we have to ensure that certain key employees are always being carried on with the team, so that as and when there is any requirement in terms of running the company, that requirement is being taken care of by this key employee. And as a process, I mean, as a liquidation process, and also in a way to market the company, the liquidator can aram se focus on that particular aspect. Third is with respect to certain risks, which would include the compliance risk majorly, I would say. Now, what do I mean by a compliance risk? So when we talk about compliance risk, see, compliance risk emanates from the fact that during the liquidation process, the liquidator may find it extremely difficult to do certain compliances, right? Like for example, like as I said, we were engaged to do compliances during liquidation for a stock exchange listed company. One of the compliances which are required is that within 45 days from the end of the quarter, or 60 days if it's an SME thing, we'll have to have a board meeting in which we will have to approve the results. And within 30 minutes of the end of the board meeting, the results have to be uploaded on the portal. Within 24 hours, entire results have to be uploaded using XBRL. Now, this is a basic compliance requirement. Now, we know for a fact that we cannot even have a directors meeting since the directors have already resigned. Or it is liquidation wherein the entire company is in the operation of the liquidator and the director's duties are discharged. Or even let's say we are continuing the director show, then but the directors will not have any authority to approve the financial statements. Now, given these kind of scenarios, definitely it's a challenge for us to comply with all of these requirements in a one go. So therefore, compliance of the like one of the major challenges for us is the risk of non-compliance. So as a liquidator, my sincere advice to all the liquidators out there and all the insolvency professional is that, see, we know there are certain compliances which we cannot do for various reasons, but I would rather suggest that we have to ensure that sufficient proof is being maintained by us to justify that we have been applying, or we have been putting efforts by which sorry. So we have been putting efforts by which we can justify the regulator IBBI or the NCLT to state that, okay, even after considerable efforts, I was unable to complete this compliance, or even after considerable effort, I'm unable to complete this legal aspect. Like for example, as per the Companies Act, you need minimum 2 directors. Let's say all the directors have resigned. So we should at least have some kind of proof to say that we have been trying to search for a director, but we could not find one, or maybe nobody was showing any interest to become a director of this company, considering that the company is undergoing this process. So this way, we can, we can provide for certain risks, or maybe we can we can justify that we have put forward our efforts to ensure that this kind of compliances are taken care of. But even after such efforts, we were unable to meet such kind of a situation. So that is one. Next is with respect to legal risk. Now, what is a legal risk? The moment we are continuing the business operations, it might so happen that we have violated maybe certain environmental laws. And let's say some kind of action has been initiated by the respective pollution control board. No, usually that will amount to huge amounts of penalties or lawsuits being imposed on the company, right? And this will also have a value on the reputation of the business of the company. Now, with all this in place, the liquidator will also have to take a conscious call that whether, okay, boss, see, these are the kind of risks I have, and this is a very huge possibility for me that this might happen. So should I be doing this or not? Like, should I be running this company going forward or not? Will also these challenges will also help the liquidator to understand whether or not to run the CD as a going concern. Nextly, on a from the customer's point of view, if you identify, see, a customer needs assurance and certainty of supply. Now, when they are unaware whether this company is going to be shut or is going to continue, it will become a huge challenge for the liquidator to convince the customer to give the order. So maintaining this order book will also be a huge challenge, considering that there may be certain hesitation from them to to give the orders to the corporate debtor. So even maintaining the customers will be a very technical thing. Next is with respect to creditors pay demands. I think, yeah, as I told the credit cycle, we have already discussed this. Supplier and customer relationship. Now, this will again be a challenge. That is where we have a supplier who may not be, see, irrespective of the credit period, they may actually not be interested to continue providing any goods or services. So, I mean, because they may misuse the situation we are in, or maybe they have been guided by the erstwhile promoters so that they can trouble us. So any of this can happen. So therefore, all the liquidator should always ensure that there is an alternative in place, and that alternative should be somebody who can, or something which can assist the liquidator in a worse situation where the kind of recovery is not as anticipated by the liquidator and the team. So therefore, having a dual strategy to tackle this kind of suppliers, customers, or creditors will be of utmost importance during liquidation process. Yeah, the next challenge is, again, it's a typical challenge for any business, that is with respect to controlling the external factors. Now, what are certain external factors? There can be change in the law, or there may be certain economic downturns, like there may be certain dharna or protests in the respect to business. And there may be a possibility that the existing employees will start agitation against the company for the past dues, etc. So these are all the risks which.
Sir, can I interfere?
Yeah. Go ahead, sir. Go ahead, sir.
Are you showing any slides for that matter?
No, sir. Actually, there is.
No, I thought, because since your video was not there, then I thought some.
Yeah. No, sir. Actually, there was a problem in loading that on my screen, so I'm sure seeing from my mobile.
That's fine. That's fine. I thought you are doing something.
No, but I will circulate it after the meeting,
fine,
sir.
sir. Yeah. Thank you.
So, yes, sir. So coming to this, the external factors. So as I said, these external factors will have a huge concern, particularly because the liquidator, and for any business as such, the external factors will have a huge problem. And more particularly, the external factors will have a concern when it comes to a liquidator. The reason being that there will be more, the kind of external factors will have a huge impact when the company is in liquidation than when the company is normally being run by the business people. The reason being, when a company is under liquidation, and particularly when there are certain changes externally, firstly and foremost, all the stakeholders who are dealing with the company will look at this company as their secondary line of responsibility. That they will first try to cater to their other customers only then they will try to address if there are any concerns we face, because they would have definitely had some kind of a financial problems because of us not making the payments. That is, the erstwhile management unable to make the payments to them. So using that as a cause, it is but for natural for them to shift their focus on to better companies or better clientele or customers than us. So the moment there are external changes in terms of regulatory policy or any new laws being introduced, regulations being altered, it would have, if it is in benefit, it's okay. But if it's an adverse kind of an impact, the first ones to be impacted will be companies undergoing stress, because the other people in the ecosystem will not have that kind of an empathy, considering particularly because they ultimately it's their business as well which also gets affected. So having a control over this external factor will also be a huge challenge for the liquidator. Next is with respect to the term of continuity of this business. Now, see, if we generally, when we look at businesses, the businessman, or I mean, whosoever is running the show, the shareholders or the directors, they have a vision. They know that they're going to run this for a particular period in time. They're going to introduce a particular product at a particular time. They're going to sell a particular product at a particular time, and they're going to time their inventory, production planning, and everything will be at the top notch, because they always look at a business from a point of view of running it for a period of 2 years, 3 years, 5 years, 7 years. There's a policy made for that. But unfortunately, when it comes into the liquidation, the situation becomes such that as a liquidator, we will be focusing on running this for a shorter period in time, because we are not expected to run it for a longer period in time. So which means at the most what we'll do will be continuing what the little piece of work we are doing. We will not have the liberty to actually explore the full potential of the company. Now, why is it a limitation or a challenge? Because we know for a fact that probably what we are doing may not actually fetch to continue this as a going concern. And with a limited investment, we can actually make better. But that would be very difficult for us to go and convince before the creditors, or before even to even gain the interim finance. So over here, I'll just write, I want to take one example of from my experience working at ENY, where we were again the same. I was basically, it was a time of COVID, when it's a company in Bhuj, Ahmedabad, AMW Auto Components and AMW Heavy Work. So it's basically one is with respect to auto components manufacturing, tire and all. The other is with respect to manufacturing the complete truck, the motor vehicles. So now, in one of the unit was completely shut. There was no operation even before the CIRP. The other unit was functioning with employees, and there were legal team, sales team, marketing, and all that stuff is there. So we always used to have active meetings with all of them to do the production planning. There's always a huge crunch. The CEO wanted some kind of demands from us. They wanted more funding, etc., which we obviously we cannot. We wanted to, as far as the RP is concerned, the clear instructions is that from the COC is to optimize whatever resources the company has currently, and not to go back to the CD for any further payments. So at that juncture, what we did was we did a detailed planning. We had an idea in place that, okay, if we raise a particular amount of interim finance, be it an X amount, when we did the math, there was some amount which we needed as an interim finance from the creditors. If had that interim finance flown, we would have maintained the existing demand order book. We would have been in a position to meet the existing order book, and also would have been in a position to pay the interest on the interim finance regularly without any default. And going forward, that would have been a first step for us to scale it up or to bring more orders onto the order book. We made a detailed presentation. We did the entire calculations and went to the COC. But I'm probably at least 10-15 minutes down the presentation, the COC wasn't interested to even understand what kind of benefit it would help. They were like, okay, if the company is continuing, it's continuing till the time it continues to continue. Otherwise, just stop the show. So now, in a business, as insolvency, as professionals per se, we are all firstly professionals, then maybe we have become insolvency professionals. So we understand that there will not be any business in the world which will not look for some funding. which is only looking at its internal accruals, of course, it is possible considering that there is no finance cost as of now. But depending upon the type of the business, depending upon the type of the problem, there may be a need for certain funding to be in place. But unfortunately, as a liquidator, we don't have this privilege. Ideally, all of us liquidators or RPs, when we run the show as a going concern, one of the assumption in our mind should be that we will not be getting any additional fund. Whatever we are making within this business has to be again, kept back into the cycle of business, and we will have to try to make certain money out of it. So the idea, again, coming back, the idea is not to make the profits or to turn around the business during this process. The idea is only to run it as a going concern. So as long as that is there, that's fine. But when it comes to balancing this short-term continuity with the long-term, value maximization of the corporate debtor, that will become a huge challenge for the liquidator. So that's one aspect of it. And next, parallelly, when we are running this company as a going concern, also trying to explore the option of selling it as a going concern, doing both of this at the same time will be one of its kind of a procedural challenges for the liquidator. Because on one hand, you'll have to manage the operations. On the other hand, you'll have to run a transparent process such that there are people who are coming forward and taking the company as a going concern. So usually this is possible when there are good enough teams who are handling these roles separately, so that the liquidator can oversee the entire part of the implementation. Next is with respect to cooperation from the directors. Obviously, this is a very common point.
May I ask one question?
Yes, sir. Sorry. Go ahead, sir, Anil, sir.
Yeah. So, as you say, we have to run the company or corporate debtor as a going concern. But, if you don't make payments, if you don't, pay your employees, how is it practically possible, especially when there is a moratorium? You can only avail the essential services during CIRP.
Correct.
But then how come, is it practically possible? Nobody will be, giving you credit for an indefinite period, or, they will not extend the services to you normally.
Definitely.
But how is it practically possible? I mean, have you faced such a situation where, without making the payments, vendors and all these suppliers will be providing the goods and, raw material, services to you without any payments, because normally liquidation and these processes, although there's a restriction in the period, 180 days and all that stuff, but still, sometimes the processes take 1 year, 2 years. So then how is it possible? I don't see, any viability in terms of running the business as a going concern until the law is amended, there.
I agree, sir. So, sir, that's where I was coming to. Basically, this decision whether or not to run it as a CD is absolutely what the kind of discussion you're trying to make is obviously the basis of you to decide whether to take it as a going concern. So when there is no business in the company, no cash in the company, I mean, no amount to make any payments. And when you very clearly know that no vendor is ready to give anything on credit, even for me to run a working capital cycle and pay back. So that should be one of your basis to decide that in your opinion, it is not going to be, it's not going to be practical, and it's not possible to run this as a going concern. But if you ask me for instances, whether it did ever happen, it did happen, but not because of cooperation from vendors, but because the company had funds or had business in hand, but it was only hurt due to the huge finance cost. The moment the finance cost is set aside due to moratorium, the money generated from the business was very much available to be paid off during the process. So one such example I can give is Sharon. There's a pharmaceutical company, pharma manufacturing company based out of Mumbai. So it's a similar situation, sir. It was into CIRP for almost 6 years because of litigations. There has been an implementation which was proposed and it failed, etc. But during this entire 6 years, the business went on because the employees stuck to the company, because they know that there is business, there is money in the company. It's just that there is no money available for them to repay the entire debt. So this very situation which you are discussing in this closed group is purely for such companies where there is a business possibility, there is some kind of money available, some kind of money to be rotated, and the vendors are also in place, not having too much of defaults from the company. There is a possibility of continuity. Otherwise, as you rightly said,
My question is that even if there is a money in the company, All right. But practically, can you use that money during the CIRP process?
Absolutely,
You cannot.
sir. We can run the company, sir. We can use it for the operation of the company. That's very much allowed.
No,
So,
but then there is a restriction on the payments to be made to the vendors, suppliers.
for the past dues, sir. So I won't be making payment for the past dues.
But then, how would traders or suppliers, they will, provide you the, goods or services if your past dues are not cleared?
They do, sir. There are instances where they did, or there is always a chance for us to change the vendor also, or to go for reverse auctioning and try to go for a new vendor. And this is very much possible. It's not like it's not happening. There are industries which have run during the process, which have made money during the process. Like, for example, SR Steel. SR Steel has made much profit in terms of its EBITDA than when it was doing before the process. So that was one of a case study for generally for in our space of IBC, where the business was strategically run even during the CIRP. So there are instances where they definitely had run the company, they definitely had certain resources, but the examples are like very few. We will not be in a position to find too many in cases where they were able to pull it off. And particularly these cases were resolved during CIRP only. There are very few cases which ended up in liquidation, and in liquidation, handling it will become much more painful because the very term liquidation will threaten every vendor, because they're not sure this company may close anytime soon. So they will definitely not be willing unless there is a complete prior payment. And as you rightly said, sir, in many cases, vendors hesitate to supply till their early dues are paid. For example, lessor, let's say we are taking a property on lease. He will not renew the lease unless his old dues are cleared. Now, that is a huge pain to handle. So in few cases, what liquidators or RPs are trying to facilitate is that, okay, they're trying to say that, fine, what we'll do is you increase our rent for this further period, so that your past dues are naturally being covered in this increased rent. And we will try to pay this increased rent because we are now in a position to pay the monies, but we can't pay you for the old dues. So this way, they're trying to make some kind of a negotiation. Similarly, employees also, maybe for 1-2 months, their salaries wouldn't have been paid. Now, going forward, we pay them, but they will definitely have an expectation that the arrears has to be cleared, or at least TDS has to be deposited with the income tax. So some kind of arrangements will be tried to be drawn when we know that there is a business. Otherwise, we will tell them, boss, we can't help you, have to file your claim. But when we know we can run the show, we can definitely have some kind of a solution, sir. But particularly in liquidation, it's very, very difficult. Because if an investor is not willing to take up the company during this process of CIRP, even though there is business, then the possibility of it being run continued in this liquidation will be a huge question mark.
Sir, so do you have to take a prior permission from NCLT or COC to make the payments and run the company as a going concern?
For COC, sir, from COC, yes. In CIRP and even in SCC, so the cost, only to the extent of cost, we will take approval. Like, for example, going concern means we have to pay a lot of salaries, even renew a lot of lease rentals, etc. So all the costs we have to bring forward before the COC. In fact, under the CIRP regulations, now there is a mandate to have at least, and in every meeting, there is a mandate to put forward the proposal on the operations as well as on the cost. So the RP has now a statutory responsibility to explain what is the status or update on the operations. Parallelly, what is the cost being incurred for the same for between 2 meetings. So on every meeting, we are responsible to put forward the CIRP cost statement explaining what went on with the operations and what amount of expenses have incurred in the operations from last to now, and get it ratified from the committee. Now, this is like a kind of an SOP which Big Fours follow whenever they're taking up mandates with running operations. So that you're absolutely right, sir. Even though the COC, but COC will definitely have an authority to tell the RP that, boss, there is no point running this company by incurring so much of expenses. Let us rather place that amount in a interest-bearing fixed deposit, so that tomorrow COC members may actually have a better realization from it, rather than using it for the operations, considering the business is not making much thing. So COC may opine it, but ultimate responsibility will be on the RP to decide on it. Same is the case in the liquidation. Liquidation, if firstly we should form an opinion whether we can run the CD as a going concern. And if we feel yes, then we should consult the stakeholders consultation committee. Now, stakeholders consultation committee may give any advice. They may tell you, boss, you do it, or they may say, no, don't do it. Ultimate decision is with the liquidator. So he has to decide on it. So that's why there our role becomes much more important, to understand the very aspect of whether running this business is helpful in terms of marketability or realization, or will it be more painful in terms of burning the existing available cash. So that is something usually, because we are aware that we don't have so much cash that we can run for a couple of months without making money. It's only that the cycle is good when we know there is a good order book, when we know there are employees who can execute it, when we have a strong confidence on it, and we also have a cooperation from the management, we can take such calls. The moment, sir, in my earnest opinion and in my limited experience, the moment the existing management gives up, there would be extreme difficulty for the liquidator to run the show, because all relations of clients, customers, suppliers will be routed through that individual. Now, the moment that gentleman or the lady is not moved away from the business, that will have a huge impact on the RP in taking over that position. So it's always important for us to make use of their services to ensure that they assist us in continuing the show. So that's another challenge which we face during this process, honestly. Yes, sir. Can I move forward, sir? I mean, move ahead. Yeah. So coming back to the other challenges which we face as a liquidator during
Yes, you can move forward.
Yes, sir. Thank you. So the other challenges which we have, which we see when we are managing the CD, the business continuity during the liquidation process, is again, as just we discussed, with respect to the cooperation from the directors or the employees of the company. So it is usually the case that the employees of the company have natural inclination towards the erstwhile promoters. So as long as the promoters have, we have certain cooperation from the promoters, the employees also tend to continue to cooperate with us. But there may be a situation where the employees may per se be actually more happier to work under the liquidation process, because they know that their salaries are 100% assured. So there are few employees who will understand it and they will try to continue till they realize all of their dues. So that possibility is also there. But again, few employees who are kind of motivated from the erstwhile promoter, and when the promoter realizes that they may lose their business, they may lose this entire company, and when they stop cooperating with the liquidator, there the liquidator will be in a huge problem, because he would have already accepted to undergo to execute a particular contract, or maybe to deliver certain goods or supply certain things, and suddenly he realizes that all the employees stop coming to the company, or they do dharna, or they are doing certain strike and they are not cooperating with you. So the existing business is gone, the business assurance is gone, and the market reputation is gone, and that will thereby lead to much lesser chances of recovery from the public. So I'm not saying that this is 100% sure to happen, but this is definitely one of the risks. So right from the beginning, the RP should try to mitigate the risk by directly coordinating with few of the key employees and trying to gain their confidence right from the beginning of the process, be it the RP or even the liquidator. So that will become extremely important for both the as a role as an insolvency professional, to ensure that the the dependency on these employees or on this workmen should be as limited as possible. And at the same time, of course, we cannot eradicate that, but we should try to ensure that if there's a possibility, and I'm assuming we are having a running show, we are able to run the show business. So in such situations, having new employees who can substitute these employees, and within the limited budget we have, will also help the liquidator to ensure that his own set of team is there who can help him even when there is no cooperation from the director. And finally, a few other aspects is that when there may be a situation when we have certain assets which are which are obsolete and which cannot be marketed, but still, as a matter of process, we may have to deal with all such assets. So there are now certain regulations which are helping us to do such kind of a sale. That is, even though we have an entire business, probably the investor may not be interested to take the entire CD as a going concern, only because there are certain assets which are of no use, and that will have a huge problem for the new investor to take any burden of. So in such cases, we can either go file an application for disclaimer of that assets, considering there is no much value or anything of that sort. Or we can, as a liquidator, can also go and categorize it as a not asset not readily available for sale, and do the process as required under liquidation regulations for that. Of course, this is not majorly focusing on the business continuity aspect, but this is again one of the key aspects with respect to understanding the business of the company. So these are various challenges, I would say, with respect to a liquidator trying to trying to manage the business of a company in terms of its continuity. Now, when it comes to the next aspect of sale, so once we are doing this role of managing the CD as a uh, uh, going concern, the next immediate aspect for us is to go for a sale of the CD as a going concern. So how do we conduct this aspect of diligence? So just like how we do for a resolution plan, wherein we provide for a virtual data room, giving all the information with respect to the operations of the company, a similar exercise has to be repeated even in the sale as a going concern. So one has to understand that sale as a going concern has various similarities with respect to a resolution of the company during CIRP by way of a resolution plan. Because even in the case of sale as a going concern, or comparing it with the sale, or with the resolution of the company during CIRP by way of a resolution plan, the ultimate idea is that the entire company will be continued by the next management as a going concern. So when we run the business as a going concern, the kind of inputs needed for somebody to buy will remain the same even in CIRP or in the liquidation. So it's always important to maintain a document like information memorandum with all the operational updates, financial updates, revenue, and what kind of cost you're incurring, etc., has to be properly captured. What is the employee cost you have? What is the material cost you are maintaining? So all of this has to be properly captured and provided for inspection to the prospective bidders. Now, when we are
Sir,
doing,
one thing, may I ask one thing?
yes,
Is that when you do a sale as a going concern of a company, in CIRP process, what happens is when the company is under CIRP and then there is a resolution plan, the company gets, the shares get delisted on the stock exchange.
correct.
Now, is this case similar in case of liquidation also? When you are putting up a company on sale, then will the company get delisted from the shares will get delisted?
From the
What
stock exchange, you're saying, sir?
Yes.
Sir, ideally, as per NSC and BSC circulars, the moment a liquidation order is passed, they are suspending the trading. So
Right.
that is very clear. They're suspending the trading, but they are not delisting automatically. There is no compulsory delisting because of liquidation. Also be offered when you are doing a going concern of the CD. So in two modes, one mode is sale of the complete company as a going concern. There, the listed entity status may also be continued subject to condition that they are complying with all the requirements of the stock exchange.
No,
That one,
what in CIRP, what happens is the shares get extinguished.
yes, that is there.
So in liquidation also the shares get extinguished.
That extinguishment, but yes, sir. So I'll tell you, sir.
But I tell you practically as an IP, I'm telling you as an investor also, retail. Actually IPs should take up this issue seriously with IBBI or stock
Yes.
exchanges. That when there is a change in when there is a CIRP resolution, new promoter comes in.
Correct.
By virtue of resolution plan, new resolution applicant will take over the business, take over the company.
Correct.
And substitute the original promoters.
Yes.
Now, in such cases, there should be, the writing off of the promoter's equity only. Retail shareholders should not suffer, who are the, small shareholders. They should not suffer because of this process. See, there's in any case, there is a change in the promoters. All right. So the promoter's shareholding, which is always declared in the stock exchange, there is a separate category of promoter shareholding. There is public shareholding. So, why should small shareholders bear a loss, or their investment should be written off just for no fault of theirs? To the best, only the promoters' equity should be swapped with when the new promoters take over, they should be given the new security, the shares of the existing promoters, and they should carry on the business. But
Correct.
These 25% or so, small holdings, they should never be impacted. Even in case of liquidation or even in case of CIRP, this is a very serious, because hard-earned money of the small retail investors, it's lost. So for this reason, there should be some change in the law, to protect the minority or these public shareholders who are the retail investors or small shareholders. They should be seriously taken up, with IBBI. There should be a change in law or maybe with SEBI or stock exchanges, they should put up this issue with the IBBI that the retail investors should always be protected. Only to the extent of promoters, shareholding should be swapped.
Correct, sir. So I think this was discussed at the SEBI level in the board meetings as well. But what they came as a solution was, so they also realized that definitely there is a dilution in terms of the value of the equity to the small shareholders as well. And for an SRA, a new applicant to come and take over the company, particularly listed company, they will be interested to have higher stakes so that when they do good in the business, they can recover right from the market itself. Like, for example, you take a Patanjali. Now, Patanjali has taken over Ruchi Soya, and today the very holding of Patanjali is so high that whatever they have put in for recovery, for payment to creditors is already realized through the increment of the value they have in the equity. So definitely they want to offer it. So what they did, sir, as a regulation policy, they amended SCERA, the Securities Contract Regulation Act, by saying that in an event, a resolution plan is being filed in case of a listed company, at least 5% public shareholding has to be retained. So where you were saying that the entire public shareholding has to be retained as is, while the regulations say that it cannot be lesser than 5%. So today,
no, but 5% means 5% of all the shareholders, retail shareholders.
No, sir, for the public. So let's say the public,
5% of all the shareholders or only few shareholders.
No, all, sir. So ideally,
because I have lost completely, in most of the cases, I have lost. I didn't get 5%. Na?
That's but in Patanjali, they actually gave some shares, sir. 1/10 of the shares.
5% law is there, but you never say, for example, Birla Tires. Birla Tires, when it went into liquidation, or it was, there was a resolution plan. Nobody got. We didn't get the shares.
Maybe they delisted it, sir. They delisted it.
No, they delisted it, all right, but then.
For delisting, there is no mandate against it. There's no payment.
No, all right, delisting. For even then, when fine, the new promoters want to delist the company. That's all right. There's no harm, but they should be, doing it properly under the, exiting guidelines of the SEBI.
But sir, section 53.
Delisting guidelines should be followed. Exit opportunity should be given to the small shareholders. Even in that case, it should be done in a proper procedural mechanism.
I think as per Section 53 waterfall mechanism, shareholders and preference shareholders and equity shareholders are kept at the lower lowest level. So I think amendment of the law itself is required in case
correct
shareholders are to be protected.
Correct. Even small shareholders
itself is envisaged accordingly. So.
It's serious, I mean, or if, all right, new promoters want to delist the company, fine, there's no harm in it, let them delist. But, this should be done under proper delisting guidelines, following the whole procedure of giving exit opportunity to the small shareholders,
Yeah, sir, actually what happened, even the delisting regulations were amended. So in all the situations, they are favoring this current practice. Even the delisting regulations say the resolution plan may not offer anything. That's very clear. If at all it offers something, then they provide that there is a particular criteria. Otherwise, a delisting per se approved by the NCLT without even a payout is being deemed to be approved even during the as good as approved under the SEBI regulations. So this what you're highlighting has actually been discussed, but they feel that ultimately, since the first in line, the creditors were not able to make anything. So the last in line, the shareholders should, including the public or the promoter shareholders, should not have a higher priority. That's how it was being dealt. That's a regulatory thing, but I understand your point. Probably there has to be some weightage given when it comes to retail investors who are having investment, let's say not more than 2 lakh rupees or something like that. So then at least some kind of a protection has to be offered. Only protection I see there is that if at all the investor wants to continue the company as a listed entity, then at least 5% public shareholding has to be maintained at the time of submission of plan itself.
No, but actually it's not maintained. I'm telling you. But even if all right, small shareholders, I never seen or never heard anybody getting this shareholding under 5%. Now, basic problem is that SEBI says that creditors have to be protected, payment has to be given. In any case, creditors are taking the haircut.
Yeah,
You
yeah.
know, so it hardly matters. See, by continuing the listing of the company or by protecting the minority shareholders, there'll be no effect to the creditors as such. Because in any case, shares are being traded on the stock exchange.
That's
You know,
true.
by extinguishing the liability of the or extinguishing the shares of the retail shareholders or small shareholders, how the creditors are going to get affected, I don't understand. Because it's a market trading is the dealing of sale purchase of the shares on the stock exchange. How would the creditors benefit by delisting or extinguishing the shareholders
No, sir.
small shareholders?
Only way they can benefit is instead of that payment made to shareholders, they will instead be happy if that money is paid to them. So that's how.
No, but how is that? Because the shares are being traded in the market. The
That's
company
true, sir.
is nowhere involved. I mean, how will the creditors get impacted? I don't know. Because the moment the shares are the stop from trading, the company is not going to get impacted. Only the small shareholders are going to be impacted.
Correct, correct. No, no, sir. Actually, how that's working is that if at all we continue the retail shareholders as it is with the holding, the investor will definitely have a loss because he is not getting the 100% equity. He's only getting, let's say, 56%, 62%, maybe the 38% is held by the minority. So if that entire minority is being continued as holders, so he is losing out on that value which he is able to build for the 38% of the company. And he has never brought that money. That money which these equity shareholders have actually brought at the initial IPO stage or any stage has never gone to him. It was already eroded and the company's business has eroded. That's why it ended in the situation. So it's all like linked, sir. The motive of the PRA, that is the investor who is coming in, he wants 100% control. If he needs 100% control, shareholders have to be existed. That is, extinguishment has to happen. If extinguishment has to happen, he is not interested. If he may still pay some money, but creditors will not let them pay some money because they want that money to be paid to the creditors instead of to the shareholders.
No. So what I'm trying to saying is that let him get a higher stake. No, I mean there is no objection to it. Only thing is that he can increase get the additional shares in the company.
Correct.
Dilute let the public shareholders or retail shareholders retain their holdings. He may be allotted additional on preferential basis or private placement basis or preferential. His equity can be increased. So automatically his stake will increase.
No, correct, sir. But for that, again, he has to bring new money, no, sir. This is easier for him. By paying the creditors, he is able to get 100% equity control, which is 100% value of the company. So it's easier for them. I mean, that point of view. So, but I understand your point. Logically, definitely the retail investors are losing, no doubt. Operational creditors are not making even a single rupee, same as the shareholder.
Correct.
Yeah,
Which
so
is
that's
not fair. I think which is not fair, which
That's
is
correct. That's correct. I mean, ideally, till now, the only focus is honestly, when they talk about interest of stakeholders, the only stakeholder they're talking is creditor. But instead of saying interest of creditors, the law only says interest of all the stakeholders. But I have never seen any process which actually discusses or talks about protecting the interest of all the stakeholders. The only stakeholders the entire process is surrounded is the creditors. That also financial creditors, and in the financial creditors also typically secured financial creditors.
correct.
So the stakes are only focusing around them. But I think the time will come, sir, when what you pointed out, definitely the time will come where such kind of.
Actually, it should be raised in the forums,
Yeah.
because
Correct.
I mean, they want to erase the equity of the big investors, big QIPs. They should take a hit to some extent, maybe say
Correct.
the qualified institutional investors or QIPs. They should surrender part of their equity because they have a major chunk of holding out of the public. But small shareholders should not be touched.
Correct. I agree, sir. I think that way, because for the QABs, it doesn't matter. It's just one out of many.
Yeah.
But for retail, it is a huge pain.
No, even then they should be touched only to the extent of say 50% or so, and then the promoters' shareholding can increase. But these small shareholders who have the shareholding worth 2 lakhs or something, they should not be touched. I don't know why this is not being brought into. But somebody should raise this point seriously. It's a major jolt to the small investors, retail investors.
But to continue your question and maybe continue that discussion, sir, with respect to listing status during liquidation. So that's a very interesting element we need to discuss, which is also part of the managing business continuity during liquidation. One aspect, as I said, is as per NSE and BSE circulars, the moment the liquidation order is passed and it is intimated, they are suspending the trading in the companies. So the trading is being suspended, but the compliances are continued to maintain the listing status. As and when this entire company is being sold as a going concern, the NSE and BSE have a criteria that at least 5% of the public shareholding has to be maintained, and then rest of the shares may be delisted or not delisted, sorry, may be extinguished, and the new shareholder will come in. So corporate actions has to be done to induct the new shareholders and get those shares listed, for which in principle approvals from NSE and BSE have to be availed. And the NSE and BSE are facilitating this process, and then they are also giving the trading license to initiate the trading of the shares in the company. So one of the value additions when a company is undergoing liquidation, particularly a listed entity is undergoing liquidation, one of the value addition is to acquire a listed entity. So there are instances where investors were looking for being a listed entity. And then subsequently, they will merge their unlisted company into this company. So for somebody who's looking at such a situation, then a company, a listed entity undergoing liquidation during CIRP or during liquidation will be a very good target where you can invest some money to take over this business. And also you can later make this business into a functioning one. And similarly, your other unlisted business may be merged into this business, and subsequently you can make it into a listed entity. So this is a very good opportunity for such kind of investors. And secondly, when we're talking about this business continuity part, particularly with respect to maintaining the listed entity status, one challenge again there is that when we are the very process of giving effect to a sale as a going concern versus approving a resolution plan has a drastical difference. What is the drastical difference? When we go for a resolution plan, it is first approved, first examined by the RP, approved by the COC, and finally approved by the NCLT. So there is a process by which it's happening, and there's a document, resolution plan, which will tackle the 1, 2, 3, the three aspects of it are being tackled in the resolution plan. But when it comes to the sale during CIRP, there is no approval from the committee for the sale. There is no approval from the NCLT for the same. The only approval will be provided by the liquidator, and that happens through a transparent process in case of public auction. In case of course, a private sale, then definitely you go back to the NCLT. But I'm assuming it's a public auction and we are going for sale of CD as a going concern. Then what I'm doing is I'm telling that I'm assigning a value, a reserve price. So already I'm deciding the value, or rather assigning a value and asking others to bid on it. Whosoever will be the highest will get the entire CD as a going concern. Now there is an obligation on me to sell. There is an obligation on the other fellow to buy. At times, of course, as a liquidator, I may opt not to sell, but on the other fellow, there's always an obligation the moment he participates for him to buy this asset. Otherwise, his EMD will be forfeited as per the regulations. Now, during this process, the most I'll give him is a sales certificate. Now, for him or for the buyer, if it is a resolution plan by which is approved under CIRP, it is easier to submit that resolution plan before MCA, RBI, or any regulatory authority to say, these are the terms subject to which I've taken over this company. But when it comes to sale as a going concern, the concept is so new that it will be extremely difficult for regulators or for others to understand what actually transpired. How did you take this liquidation as a going concern, etc.? Because there is no order of NCLT. Only thing you have is a sale certificate from a liquidator. So as a matter of practice, in various NCLTs, the practice adopted by liquidators was that after the sale, they file that entire, they ask the the successful bidder to give what kind of reliefs and prayers they need, and they file for an IA with the NCLT. So few NCLTs are actually considerate and are passing orders giving such kind of reliefs, considering that it's a going concern sale. However, I've witnessed in NCLT Mumbai in one of the matters where they did not consider the IA, treating it to be infructuous, saying that no, there's a sale, it's happened and it's closed, there is nothing we'll have to pass because it's a going concern sale and not a resolution plan kind of a thing. So it is extremely important. So the solution to it, in my opinion, is when you're doing a sale as a going concern, the process memorandum has to be rock solid, giving what level of rights. You should just visualize that. We should think from the RA's point of view, that is the successful bidder's point of view. The moment he takes over the company, what level of reliefs or waivers he would expect. I mean, that is different. Like, for example, income tax benefit, etc. I'm not getting into it. What I'm trying to say is that, for example, capital reduction. So we should try to say in the process memorandum itself that any process for the process memorandum for the capital reduction, etc., pursuant to this approval, this is a single approval for the entire sale of the CD as a going concern. Thereby, all other instances with respect to capital reduction or all compliances with respect to capital reduction or allotment, etc., will not hold good at all. So now, how do we give effect to it will be the whole beauty of this particular subject with respect to sale as a going concern. So that's why when we're doing a sale of the entire company as a going concern, it is extremely important to word the process memorandum appropriately. And in my opinion, it should be the responsibility of the NCLT to pass an essential order, also taking on record the sale as a going concern and also giving certain reliefs and waivers, like relief from complete compliance of Companies Act for reduction of capital or increase of capital or allotment of shares or the appointment of directors, replacement of directors, extinguishing the existing directors, etc. So for these kind of aspects, there should be enough room to be provided to the successful bidder. See, the reason why I am emphasizing on it is that if I am selling a business as a going concern, I'm doing a business transfer agreement. So the entire business gets transferred. I understand at least that there is a change in title in terms of who owns the business now. But when it comes to sale of the CD as a going concern, what should change? Essentially, two things should change. One, the shareholding should change. Second, the directorship should change. But in my auction, am I selling the shares of the company? Absolutely not, because I don't own my own shares, right? So the shares are held by some shareholders, so I can't sell it. But I'm selling the entire company as a whole. So essentially, the investor or the successful bidder should be given the entire control over the company. Now, how is the control given? The control is only given by virtue of equity shares as well as, shareholding plus directorship. So this has to be somehow ensured as part of the process memorandum, read with an order of the NCLT. So all NCLT should facilitate applications for a going concern sale, and very basic exemptions have to be given, because NCLT is not expected to look at section 30 subsection 2, because they're not, there's no applicability of section 30 subsection 2 anymore. So NCLT has no burden in terms of understanding whether this liquidation as a going concern is beneficial, non-beneficial, etc. Only thing NCLT has to do is to take it on record and give certain essential reliefs to the successful bidder, which can help the successful bidder in successfully taking over the sale. Because usually sale as a going concern is a single shot payment. It is not a deferred payment. So therefore, they bring the money, they take over the business, entire company. What is meant by taking over the entire company? That will be a huge problem. So there will be certain steps also to be laid out, saying that, okay, allotment of equity, so and so has to be there. So the liquidator should facilitate the allotment of equity. Liquidator should facilitate reduction of capital. Liquidator should facilitate appointment of directors. And in all these stages, certain amounts of monies has to be put as a stage-wise consideration to be paid during the process. And once the money comes in, the liquidator's role to continue or run the business as a going concern will go away, and he will then shift the role to distributing the funds to the creditors under section 53, in the order of priority under section 53. So after managing the company as a going concern, the major aspect will be to strategize how to sell this company as a going concern. And when we are doing that, the process memorandum should meticulously, very clearly, minutely articulate as to how this entire transition happens from the liquidator to the new management of the purchaser. Now, this will help the successful bidder in ensuring that they are having a proper title over the entire business. And that's why it becomes all the most important for us to ensure that there is a better continuity of the respective business. Now, with respect to this managing business business continuity, there is one more aspect apart from sale as a going concern, or sale of CD as a going concern, or sale of business. We'll come to sale of business shortly. But another important aspect for the entire company to be taken over as one go is the scheme of compromise or arrangement. Now, as we're majority of us are aware, company secretaries or chartered accountants in this group, or cost accountants, that the schemes of compromise or arrangement are dealt with under Companies Act. And they have been slowly knitted into the IBC through various judicial precedents. And currently, the first 90 days of the process can be dedicated towards compromise or arrangement is what the law says. What essentially happens in a scheme of compromise or arrangement? So what essentially happens is that either the promoters or one of the existing employees, they will propose for a scheme. Now, the scheme will address as to how it deals with the payments to be made to the creditors, right? Or it's basically a scheme which is kind of a arrangement by which there's a compromise among the creditors all involved in the process. And here all the stakeholders will include even the equity shareholders, it will include the directors, operational creditors, it will include the financial creditors. So that way several classes of creditors is being drawn. So one startling difference between a scheme of compromise and the CIRP is that in a CIRP there is a cross-class cramdown. Now, what does this mean? It means that across all the classes of creditors, there is only one committee, which is COC, financial creditors. They will decide that particular plan by voting on 66% voting share. That's all. So it is called as cross-class cramdown. But on the other side, when it comes to a scheme of compromise or arrangement, it is a class-wise cramdown. Now, what does that mean? Each class has to vote on the respective scheme. So as a liquidator, we have to facilitate that, wherein we have to see to it that every class votes on it. And from the secured creditors, we need at least 75% of the secured creditors voting on this. Otherwise, also we need approvals of 3/4 only from each class. But for this, from and among the secured creditors, we need at least 75% again, which is a higher threshold than that is provided under the IBC, and that is still holding good. NCLTs have held that that is what has to be achieved during the process. So because it is a scheme, because a scheme is a code in itself, is what we have learned under the Companies Act. So since it is a scheme, it continues to operate in that fashion, wherein in a scheme as well, just like a resolution plan, you can document a lot of things, that how does this transfer of business take place? How will this happen? The existing shareholders will continue as is, because usually it is submitted by promoters. Let's say the employees submit the scheme, then they'll say that the entire shareholding will get extinguished and the employees will get the shares. So even as part of a scheme of compromise or arrangement, a sale as a going concern can be executed, but it won't come as a sale as a going concern. It will be a process run for the purpose of having a scheme of arrangement or compromise under section 230 of the Companies Act, read with regulation 2B of the liquidation process regulations of IBBA. So this way, even in such scenario, we are achieving something called as a business continuity or a going concern sale. Otherwise, we are doing a exclusive sale either through public auction or private auction for a sale as a going concern. Now, we have discussed about the public auction part, wherein I said there will be a process memorandum. We fix the reserve price based on the valuations, and then we do the auction. Whosoever has the highest bid will be declared as a successful bidder, and there will be certain stages where the liquidator has to facilitate for change in equity shareholders, cancellation of shares, and also appointment of directors, thereby transferring the entire control to the new shareholder upon payment of the entire consideration. So, typically the successful bidder. This is with respect to a public auction. Now, let's talk about a private sale. Now, in terms of private sale, how does the operation of private sale work is that, see, private sale, private sale, you can say that it has principles close to how you handle a resolution plan. Now, why I would say that is that, see, firstly, I'll quickly read out what are all the situations where I can go for a private sale. One, basically as a liquidator, I may sell the assets by means of private sale after prior consultation with the committee. And when we know that the asset is perishable or asset is likely to deteriorate in value, or when we already have a prior permission of the adjudicating authority for such sale. Now, how do we execute such kind of a private sale? Is that, if you can, I'll just show the regulation, but anyways, let's quickly summarize it. Is we as a liquidator, we can strategize, any approach. So how we can strategize an approach is that we can say that whatever approach we use for resolution plan, a similar approach we can use, wherein we'll do the proper marketing. We will invite expression of interest from various people. We can even do a physical auction between and amongst them. And then with one of them, we can again renegotiate with each of them. So I have a complete flexibility of selling my asset as a private sale if I feel that will have a more value addition than that of a public auction. And even the SCC has a similar opinion. Then we can approach the NCLT and avail a prior approval for going ahead with a private sale. So, but the very challenging aspect here is to get a convincing answer from the NCLT. See, if the NCLT is not convinced with respect to a private sale, then it becomes all the more difficult for the liquidator to do anything. I mean, firstly, the liquidator has to convince the NCLT that this is beneficial. That will be the more challenging aspect. Otherwise, if the liquidator and the SCC opine that, okay, we have some existing offers and we don't want to bring it into public auction, thereby we don't know how this will be derailed, or maybe the existing buyer may also not participate, thereby focusing to reduce the value further. So if we are apprehensive of such kind of a situation, then private sale can be a very good option. Thereby we can lock the particular price, have some definitive documentation executed with the bidder, and then go with to the NCLT for filing and all that. So probably so private sale is also one of the options for us to go for a sale as a going concern. So these are various aspects with respect to managing the CD as a going concern, and also looking at from the point of view of regulations and the challenges we face as a liquidator. So so far, any questions from any of the members attending the session? We can take up the questions and discuss it. Otherwise, I want to cover one or two couple of more concepts. Otherwise, we almost have captured all the very basic major aspects when it comes to managing the business continuity during liquidation part. Any specific questions from anybody? Otherwise, we can continue. Okay, on the group also I check. I don't find any questions. Fine.
Sir, during CIRP process, if CD does not have any asset,
Yes, sir.
COC can decide for liquidation.
Absolutely, sir.
But there is no provision in IBC to go for dissolution directly without going for liquidation, because there is no asset. There is no point in going for liquidation.
You are absolutely right.
So,
But in NCLT Hyderabad, if my memory goes right, even in NCLT Bangalore, they have directly passed early dissolutions. So, sir, there is one concept of early dissolution, which is given in liquidation regulations only. Ideally, it has to be filed by liquidator.
54.
Before. But what NCLTs are reading it is, NCLTs are, if at all the COC and liquidate RP are of strong opinion, there is no asset, there is no way there is going to be any value addition even by exploring liquidation, then along with the application filed for liquidation of the company, they can also move one more application for early dissolution of the company. Few of the NCLTs are considering it. Though it is not stipulated as a matter of practice, they are still considering it. And if they are, like, for example, so there was one case, we are talking about liquidation. There was one case where right at the time of CIRP initiation, they passed a liquidation order instead of Section 7 admission in NCLT Bengaluru. The reason being that they say that there is absolutely no creditor in this company. So the only creditors are the same management of the company, and they have no objection but to liquidate. And there is no other business, no asset, no way this is going to be done. So the NCLT Bengaluru, in a very typical situation, they said, okay, it does, as the application states, this does not deserve to be admitted into CIRP, and a direct liquidation order can be passed. And they passed a direct liquidation order. It's very strange, but they did. But the moment we have external creditors involved, they don't take that chance, particularly income statutory authorities. So that's why early dissolutions are a challenge. Why NCLTs also don't take that usually is because they feel that, what if some kind of an investigation is ongoing? There is some asset which we are not aware of. There is maybe some investigation at ED level. So we don't know that. So few don't take that chance. But when they actually see the balance sheet and understand and are convinced, and even COC is convinced there is nothing which the company has, particularly not a non-banking COC, where there are COCs consisting of either some good amount of financial creditors or maybe at least some sensible financial creditors in place, then NCLT may be convinced that, okay, it's a valid application for early dissolution along with liquidation, sir. It is possible, but it's a very, I would say that only when there is a strong evidence to prove that it deserves early dissolution. So that has to be ensured. And also, after the liquidation also, immediately we can go for early dissolution to save time. Maybe if suppose, because at times what happens, when we file two applications, NCLT will neither dispose any of it, it will keep sitting on both of it. So in such situation, it's better to first file for liquidation, close, then immediately file for early dissolution application, explaining why we are doing it based upon the grounds. If I can quickly tell you the grounds of early dissolution, it says where the realizable properties of the CD are insufficient to cover the cost of the process and the affairs of the CD do not require any further investigation. Then, upon consultation with the committee, where the committee is advising for early dissolution, we can apply to the NCLT for early dissolution. This will be a safer zone for us. Though there will be some additional cost of 50,000-60,000 for publication and claims and all that. But at least when we go back to the NCLT, there won't be much of an objection since we are coming squarely under Regulation 14. So that can be done, sir. So early dissolution is definitely a valid option, which we can explore when we know. Actually, that's a very good point you've raised, sir. When we are deciding whether the continuity of a business is a good option or not, we should also see whether to continue the process of liquidation is a good option or not. So when we know that there is no asset, even the assets are not able to cover the costs. So that's where Regulation 14 has been provided, wherein we should actually file. There's a responsibility on us to actually go ahead and file for early dissolution than to invest a lot of time to recover some money and lastly make the cost burden on the creditors. So that's definitely a valid point, sir.
Thank you, sir.
Yeah, thank you, sir. And yeah. So one aspect which I was hoping that I can try to cover during this process is with respect to the role of the SCC, the Stakeholders Consultation Committee, when it comes to managing the company as a going concern. So though I have covered in brief, there's one point I was trying to recollect, which is that typically the role of SCC in a liquidation process is to, if you see an identical role, if you compare it with the COC and the SCC, COC has a very active role as compared to SCC, because when it comes to liquidation, liquidator will overpower the SCC, because liquidator can do something which SCC doesn't want him to do, or liquidator can do something in his own discretion and applying his mind. But when it comes to CIRP, usually the RP will bound by the directions or the instructions of the COC in various aspects, be it filing for extension applications, be it filing for any kind of doing any kind of a step. Usually there is prior approvals of COC required. But in liquidation, we have a very typically different role. The reason being that, like when we look at the jurisprudence of how the process of liquidation has evolved, it has come for us obviously through the Companies Act. So in Companies Act, we had always the concept of official liquidator. Now the official liquidator is a person appointed and is also directly reporting to the High Court. So he's a central government employee appointed to the High Court and all. So there is a huge power given to the official liquidator to dispose the assets. Now a similar jurisprudence has been evolved and has been adopted in the IBC. So therefore, we don't see that a liquidator is being bound by some kind of committee. But they still say, they try to tie his hands by saying that, boss, okay, you have unfettered powers, but you need to take an advice in various situations. And based on the advice, you will have to act upon. But if you feel you're deviating from the advice, then you will have to intimate in writing in the very next progress report as to why you had to deviate from the decision made by the COC and inform the NCLT accordingly. Now, this is one kind of an aspect, and particularly talking about our aspect of business continuity. Regulation 32A, sub-regulation 5, the second part of that says that, so when the liquidator is of the opinion it is viable to run the CD as a going concern, the liquidator shall consult the consultation committee, and only on its advice he shall run the affairs of the CD as a going concern to the extent approved. Now, so this is one area where it feels like the liquidator doesn't have much of an option if the SCC advises the liquidator not to run the CD as a going concern. The reason being that the regulation reads that only on its advice. So I just I'm sharing it on the screen. It says only on its advice he shall run the affairs of the CD as a going concern, and that too to the extent approved. So it means that the role of SCC is also extremely critical when it comes to continuing the CD as a going concern. So the moment we are looking at running the CD as a going concern, it's not just the decision of the liquidator, but even the SCC has to be completely convinced that yes, we should run it, and to the extent approved. So SCC may say that, okay, see this vertical, let's not operate. There is no point. Only one vertical, let us operate. Yes, a liquidator is bound to do that. I feel that's the kind of interpretation they're trying to make in this regulation. Though in general, liquidator has a power to deviate from what is being dictated or what is being advised by the committee. But over this regulation, I feel there is then inherent responsibility on the liquidator to act upon only on the advice received from the consultation committee. Now, this reason, see, when I go to 31A, where it talks about what are all the matters they can advise to the liquidator, it includes sale under 32, including the manner of sale, pre-bid qualifications, reserve price, marketing strategy, and auction process. So now this is of very extreme importance, because earlier the liquidator was typically fixing the reserve price and then going ahead with the auction one after the other, etc. But now it's very important for the liquidator to see to it that these matters which mandatorily require the advice of the SEC has to be brought forward before the SEC's perspective. So on one hand, managing the CD as a going concern will also have to be brought forward before the SEC, even though it is not mentioned here, because only on its advice the liquidator can act upon it. On the other hand, after being managing the show as a going concern, if the corporate debtor has to be sold as a public sale as a going concern or any other aspect, again there the SEC's role is extremely important. So SEC's advice has to be taken in both the aspects. However, it is a situation where suppose the advice of the SEC, in this case, when it comes to sale, if the advice is different, then the liquidator may differ from the advice of the SEC. But when it comes to running the CD as a going concern, then the liquidator cannot deviate from the advice given by the SEC. So that's where the role of the SEC will become extremely important when it comes to taking a call on managing the business, on continuing the business of the corporate debtor even during liquidation. So,
you see, sir, one thing.
Yes,
now
sir.
it says that the consultation committee will be comprising of all the creditors.
Yeah.
It will be both operational as well as financial creditors.
Absolutely, sir. All of them.
So if there are, say, 100 creditors or 100 plus, so all of them will have to be part of the consultation committee.
No, sir. I'll tell you. So that's where 31A3 will come into picture. What it says is, firstly, we will have all financial creditors in place, just like how there is a COC, sir, irrespective of the number. But for every other class, that is class meaning financial creditors in a class, let's say home buyers, workmen, employees, government departments, OCs, shareholders, for all of them, they will be nominating their representative. So if there are 100 workmen, only one fellow will be allowed in the meeting, but he will vote on behalf of all the 100 workmen. If there are like 1,000...
Correct. Now, in case of representation, now their representative has to be compulsorily a resolution professional or...
Not required, sir. Not necessary.
Not
Even
an insolvency professional, not IP.
Yeah, not necessarily.
Okay.
Yeah. So but as a liquidator, we have a responsibility to facilitate a process by which they can nominate one among themselves. So maybe it's generally in workmen, the union leader may come and sit. For employees, maybe one among them, they themselves can nominate somebody. So only that process, as you rightly said, there is no mandate to have a IP. Even for financial creditors in a class, even if they are home buyers, there is no need to have an IP to sit in the meeting. One of them can come, but they will be representing the entire class. They will be voting on behalf of the entire class. It's going to be very tedious, sir, honestly, to handle all that. If it's an IP, at least we can communicate and explain. If it is a person who has no understanding of this process, it will be very difficult to first convince him on what we are doing, and then later explain. That fellow has to explain the other group. So it will be very difficult. So I was actually referring to this regulation, sir, which says that the advice of the consultation committee shall not be binding on the liquidator. And where it says that provided that where the liquidator takes a decision different from the advice, he shall record the reasons in writing and submit the records relating to said decision to the NCLT and to the IBBA within 5 days of the said decision and include it in the next progress report. So this is going to be a very tricky thing, sir, because when they say submit the records relating to the decision to the NCLT and include it in the next progress report, it is unclear. Like, should I file an IA with NCLT saying that I have gone through a separate process? Because NCLTs now do not entertain simple filing of documents. Any filing has to be by way of an IA. So if we deviate from the decision from the advice of the committee, then the interpretation is that I should file an IA with the NCLT, bring these records on record with the NCLT, and then also file it with the IBBI, inform them within 5 days of the decision, and in the next progress report, I have to include it. But I feel, in my opinion, the ideal interpretation should be that maybe some kind of a filing has to be done to NCLT as a memo, not as an IA. But in the next progress report, which will actually come as an IA, we should try to bring this on record and also inform the NCLT during the hearing. So I think that's something which can be practically done. Otherwise, it will be difficult for the hearings also to happen, because there won't be any prayer as such, other than to take on record what decision we have made. But sir, this, in my opinion, will not squarely apply to our 35A to 32A5. The reason being that it's very clearly says only on its advice the liquidator shall run the affairs as a going concern to the extent approved. So here I feel this cannot be read with 31A10 for the reason that there it is not binding, but here this is only subject to condition of the advice he can run the show. So therefore this is kind of binding and he cannot actually override this decision of the SEC. So this is one point I thought I'll explain at the end so that it will have the impact it requires. So that's it from my side, sir. And all of you, if there are any further questions or anything to be discussed, I'll be more than happy to share my thoughts. Otherwise, Anjali from ICSI, you can take this forward if there are no further questions.
Any questions?
I'll be sharing the detailed presentation. I could
Yes,
not.
sir. Please share it with me.
I will
I
do
will
that, I will
share
do
with the participants.
Prakul, Ajit Jain here.
Hello, sir. Good evening. Yes, sir.
Yeah, in one of our case, no, we have filed the acquisition plan with NCLT as we are consulting for one of our client
Okay.
to take it as a going concern basis.
Okay.
So we have filed the acquisition plan, but NCLT has rejected that acquisition plan,
Yeah.
saying that this is a normal course of a bidding
Correct,
process, so it will go. So then what do we do? Because we will require certain things.
I know, sir.
Extinguishment of shares and everything.
Absolutely, absolutely.
So,
So which NCLT is it, sir?
Mumbai.
Yeah, we had a similar experience for one of our clients in Mumbai. So that's what I was explaining in the presentation also, that few NCLTs are considering and passing. In fact, NCLT Mumbai was earlier doing it. Now they are not entertaining these applications from the buyers particularly. So, sir, here in this case, did you file as a buyer or through the liquidator?
No, file it from the buyer, because acquisition plan he has to
Yeah.
file it. No.
Correct. So you would have already bought it as a
Yes.
going
Now
concern.
our client has gone to NCLT
Flat.
because he will require certain type of
Yeah, so
things, otherwise
NCLT
how
will
we do
definitely
it?
entertain.
There is no
Yes, sir.
structure to it, to how to record the company.
Sir, ideally, in my experience, what we did in one of the cases was in the process memorandum, we have given a laid out the structure saying that upon the sale, the shares will be deemed to be cancelled, the shareholding will be transferred, and the liquidator will facilitate the transfer of shareholding. The successful bidder shall nominate the directors, and the liquidator will facilitate the appointment of directors. Karke, we have laid it out. So in the process memorandum, if at all there is a stipulated process, then you can make use of that advantage, sir. Otherwise, because there will be too much of discretion now on the NCLT or NCLAT to pass such kind of an order. So earlier they were using that discretion, but now unfortunately they are not treating that kind of a discretion, sir. So we have to see how the NCLAT also favors you. But ultimately, sir, if at all you just want the effect of it, you use the liquidator's DSC and get the written off allotment filed in the name of both the directors, or maybe existing directors. Like firstly, get the directors appointed using the liquidator, because now the MCA allows appointment of directors using the DSC of liquidator. So you get the directors appointed, and once the directors are appointed, through the directors, get the written off allotment filed. And also an INC 28 of reduction of capital filed, saying that it's a sale as a going concern. Now, if the ROC may object you, saying that no, we cannot allow this document, if at all they say that, then you can use that as a base to file it with the NCLT, then they will definitely consider. Otherwise, in general, they will not consider.
this is a very smooth process has become a difficult process now.
Absolutely, sir.
And
Earlier they were passing orders, sir. I was there. I've seen certain orders wherein they very
yeah,
clearly.
earlier they were passing the order, but this order has also come to a surprise. Then when we
Yeah.
researched it out, we thought, then we came to know Mumbai NCLT is already passing such type of orders.
Yeah.
So
So
what
I'm
kind
glad
of
I
return
told
of
you.
what kind of return of allotment we have to file? This is for what?
No, sir. So when you're doing a sale of the CD as a going concern, so the investor has to get the shareholding. And that shareholding will, the proof of the shareholding being done is done through a return of allotment. So there has to be new shares being issued, existing shares being extinguished. Now, to effect this, in case of a resolution plan, we find a lot of clauses which will protect the investor. But in case of sale as a going concern, NCLTs are not entertaining any applications filed by them. So therefore, we have to essentially, otherwise, we have to get a written of allotment filed. But in this situation, we have to make sure that the liquidator himself, through the successful bidder, is making sure that the compliances are being met.
But how will the old shares get extinguished?
Exactly, sir. So in case of a resolution plan, because the plan is binding, so the
No,
NCLT,
correct. But in this case of liquidation, how?
yeah, that's where the biggest challenge, sir. Because now NCLTs are not giving orders, and as a liquidator, we don't have a power to extinguish the shares or anything. So that's where there is a huge issue, as the sir was rightly pointing out his own. In fact, Ajit Jain sir is pointing out in one of his own cases where they have faced it and they had to go to NCLAT now. So ideally, sir, the NCLT should have entertained such applications and allowed for the reliefs. Whatever are being sought, limited with respect to companies that compliances at least. Need not necessarily be other.
But till the time the original shares are extinguished, how can you file the return of allotment for the new shares? I mean,
You're right, sir. You're right. Correct.
It'll be unnecessary, duplication or increase of the share capital.
That's true. But what can be done is that same reduction of capital also, we should assume that the sale of a going concern will lead to a reduction of capital. Why I'm selling that is, ideally, sir, if you go back to the traces of liquidation under Companies Act, the moment liquidation, winding up process starts or the liquidation starts, all the equity shareholders will become contributors actually. They are no more equity shareholders. So if we apply a similar interpretation, in this case also, they are actually not, there are no equity shareholders. The capital, everything is, because it's not like a company being run as a going concern. It is a liquidation, company under liquidation. So the shareholders become contributors and the entire capital is being disposed by way of selling of assets and repaying. So applying that logic, ideally upon liquidation order itself, the entire shareholding is extinguished and they become a contributory and a claimant. That's why if there is any excess recovery, they will also get certain money. And since we are doing a sale as a going concern, just like how no creditor is also carried forward. Like for example, like sirs, like Ajit Jain sir's investor would have paid off some, let's say 10 crore rupees or 100 crore rupees and got the asset. Now no creditor is going to follow. So all the creditors are settled by the liquidator. And that creditors will also include the equity shareholders. So this has to be one line of argument. We have to keep that, boss, I am paying you money for the company, but not for taking the equity shareholder or the creditor. All that payment to equity shareholders or creditor has to be the responsibility of the liquidator. Just like how I don't get a creditor when I do a sale as a going concern, I should also not get an equity shareholder.
No, but,
so
does the liquidation order provide for the extinguished?
No, exactly, sir. There is no order only. It is only
then how can you
sale certificate by liquidator. Correct. It's very difficult to enforce. I'm just trying to tell that this can be arguments in the NCLT, but very difficult. Yeah.
There's a technical issue in this.
Very technical, sir. That's what in the discussion also I was discussing with you, that unless they give it as a matter of right to file such kind of an application, this will not be much successful going forward. Because see, now let's say Ajit Jain sir's client faced this. Tomorrow, Ajit Jain sir will find it difficult to advise any other client to do this route. If at all NCLAT order is not coming favorably.
No, actually,
I'll tell you
that's
the complication. This was a private company. Suppose I
Okay.
advise somebody for a public listed company going concern to
Oh
be
my
purchased,
goodness.
then it is going to be a really
Ruckus, sir.
huge task.
Yeah.
How you convince because other than there is a court order, none of the department is going to do anything. You are there. You are nowhere to stand anywhere.
I totally agree, sir.
It will happen that way. Otherwise, you go to High Court, you file a separate application, make all the authorities parties, and then you say that
that's too much of pain, sir.
or you go to NCLT and ask for the relief with the separate application. So that will again take its own time.
Correct.
And how many
Actually,
parties
you
should
know,
we meet then?
that's why I was saying that, you know, the best course is transfer only the major promoters, shareholders. You know, they do it through a transfer process rather than extinguishing and getting into all that stuff. Better way is, you know, transfer only the promoters' holdings, which is easier through the liquid NCLT order or NCLT order. They should, you know, pass an order directing the existing promoters to transfer their shares to the new investor or new promoter, and then, you know, continue with the business. And maybe they should be allowed to you know, apply for or get the new shares issued to them so that their equity stake increases in the company. I think that should be the best route, and so that there is win-win situation for all. Anyways, I mean, it's a law. It's a law.
Fine. Okay.
Yes, sir.
Thank you, Rakul. Thank you.
Thank you, sir.
Yes.
Anybody else? Any further questions? Okay. So Anjali, I think we can conclude the session.
Are there any questions, participants? You can ask, otherwise we should conclude it. Yeah, we should conclude now. There are no questions.
Okay,
Thank you
ma'am.
very much, sir,
Thank you,
for
ma'am.
giving your valuable time and sharing your experience in the field of liquidation. Sir, you are requested to please share the presentation.
I will do
with
that.
me.
I'll do that now. Thank you so
Thank
much.
you very much, sir. Thank you so much.
Thank you so much, Joshi sir and Anil sir, for your active participation and questions.
Thank you so much.
Thank you,
Thank you so
everybody.
much for your valuable inputs.
Thank you.
Thank
Bye, sir. Thanks, everybody.
Thank you.